He reported on the 7th, where he failed to regularly report. And during your time of probation.
And the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you.
It's Ms. Cole, right?
Yes.
And how long have you worked for probation?
A year.
And during your time of probation, have you supervised Leon Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th. You've not seen him since.
Until he was arrested. Yes, sir.
So, is it safe to say that on April 11th of 2025, April 21st of 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required to see you or to the probation?
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report again?
April 7th.
April 7th. And have you were able to talk to him about the different reasons why he didn't report?
I called him actually on his birthday, and I told him you have a warrant, and he told me because it was his birthday, he was not coming to tell him.
Are you aware of any time while he's, since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get those messages?
I called, I sent letters, and I called his mother.
Okay.
And his mother told me that he was aware of the warrant.
I'll pass the witness.
Another questions for purposes of proving up count number 7, Your Honor.
Okay. Based, any witnesses or information about count number 7?
Oh, yeah.
All right, then, based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so, again, I've got the updated pre-sentence report, as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter? It's
I did
from,
not show it to Mr. Marcus.
and take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to the page 1, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of that program.
Okay. I guess being kicked out's better than being absconded. Anyway, all right. Anything else?
That's what the PSI noted.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in safe P. He did successfully finish the first part of safe P. The aftercare program is a part that he was kicked out of. He pled not true to count 1 as far as, I believe that counts as he was selling K2. What Mr. Yeoman tells me is that one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2, so everybody in that room was kicked out. And that really just started the downfall for him on the probation judge, because at that point he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the messages were given to him to report, he wasn't able to because he didn't know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, and as far as the possession and the weapon charge. According to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much for you to argue here today, is there? You haven't given your attorney anything. to argue for you.
Judge, I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that SAP program. And that's what he's asking to give the opportunity to do this morning, is finish that aftercare program, possibly even due to those new offenses, one of them being weapon, maybe even consider sending him to ISF Cognitive to help him make better decisions. And if you had more questions about what happened at SAP, Mr. Young is willing to talk about those.
So there was an ISF, okay, there have been 7 administrative hearings, 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally, what appears to be a week or 2 after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case of, while you're on probation for aggravated assault with a deadly weapon, you obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second. And then we're here again. I sent you to Safe P. And not only did you get kicked out of Safe P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances. And if you go back to his original PSI from 2019, from the 2019 offense, the ag assault, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct in that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate, Your Honor.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point, we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's gonna keep giving me probation. I'm gonna come in, I'm gonna write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 19-32846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty. And at this time, find you guilty of, which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. This needs to be scanned. I wrote notes on that.